The Federal Assault Weapons Ban, AWB, officially, the Public Safety and Recreational Firearms Use Protection Act is a subsection of the Violent Crime Control and Law Enforcement Act of 1994, a United States federal law that included a prohibition on the manufacture for civilian use of certain semi-automatic firearms it defined as assault weapons, as well as certain ammunition magazines it defined as large capacity. The 10-year ban was passed by the U.S. Congress on September 13, 1994, following a close 52-48 vote in the Senate, and signed into law by then-President Bill Clinton the same day. The ban only applied to weapons manufactured after the date of the ban's enactment, and it expired on September 13, 2004, in accordance with its sunset provision. Several constitutional challenges were filed against provisions of the ban, but all were rejected by reviewing courts. There were multiple attempts to renew the ban, but none succeeded. Studies have shown the ban had little effect in criminal activity, although this may have been due to the ban's various loopholes. Other studies have shown large increases specifically in the rate of mass shootings that began when the ban was lifted. Background: efforts to create restrictions on assault weapons at the federal government level intensified in 1989 after 34 children and a teacher were shot and 5 children killed in Stockton, California with a semi-automatic AK-47 rifle. The Luby's shooting in October 1991, which left 23 people dead and 27 wounded, was another factor. The July 1993 101 California street shooting also contributed to passage of the ban. The shooter killed 8 people and wounded 6. 2 of the 3 firearms he used were Tech-9 semi-automatic handguns with Hellfire triggers. The ban tried to address public concerns about mass shootings by restricting firearms that met the criteria for what it defined as a semi-automatic assault weapon, as well as magazines that met the criteria for what it defined as a large-capacity ammunition feeding device. 12. In November 1993, the proposed legislation passed the U.S. Senate. The bill's author, Dianne Feinstein, DCA, and other advocates said that it was a weakened version of the original proposal. In May 1994, former Presidents Gerald Ford, Jimmy Carter, and Ronald Reagan wrote to the U.S. House of Representatives in support of banning semi-automatic assault guns. They cited a 1993 CNN/USA Today/Gallup poll that found 77% of Americans supported a ban on the manufacture, sale, and possession of such weapons. Representative Jack Brooks, DTX, then chair of the House Judiciary Committee, tried unsuccessfully to remove the assault weapons ban section from the crime bill. The National Rifle Association, NRA, opposed the ban. In November 1993, NRA spokesman Bill McIntyre said that assault weapons are used in only 1% of all crimes. The low usage statistic was supported in a 1999 Department of Justice brief. The legislation passed in September 1994 with the assault weapon ban section expiring in 2004 due to its sunset provision. Provisions of the 1994 ban. The Public Safety and Recreational Firearms Act, the Federal Assault Weapons Ban, was enacted as part of the Violent Crime Control and Law Enforcement Act of 1994. The prohibitions expired on September 13, 2004. The Act prohibited the manufacture, transfer, or possession of semi-automatic assault weapons as defined by the Act. Weapons banned were identified either by specific make or model, including copies or duplicates thereof, in any caliber, or by specific characteristics that slightly varied according to whether the weapon was a pistol, rifle, or shotgun, see below. The Act also prohibited the transfer and possession of large-capacity ammunition feeding devices, LCAFDs. Unlocked was defined as any magazine, belt, drum, feed strip, or similar device manufactured after the date that has the capacity of, or that can be readily restored or converted to accept, more than 10 rounds of ammunition. The Act included a number of exemptions and exclusions from its prohibitions. The Act included a grandfather clause that allowed for the possession and transfer of weapons and ammunition that were otherwise lawfully possessed on the date of enactment. The Act exempted some 650 firearm types or models, including various types of Browning, Remington, and Beretta guns, as these were viewed as primarily suitable for target practice, match competition, hunting, and similar sporting purposes. This list was not exhaustive, and the Act provided that the absence of a firearm from the exempted list did not mean it was banned unless it met the definition of semi-automatic assault weapon. The Act also exempted any firearm that 1. Is manually operated by bolt, pump, lever, or slide action, 2. Has been rendered permanently inoperable, or 3. Is an antique firearm. The Act also did not apply to any semi-automatic rifle that cannot accept a detachable magazine that holds more than 5 rounds of ammunition, nor any semi-automatic shotgun that cannot hold more than 5 rounds of ammunition in a fixed or detachable magazine. The Act provided an exemption for the use of semi-automatic assault weapons and LCAFDs to be manufactured for, transferred to, and possessed by law enforcement and for authorized testing or experimentation purposes, as well as transfers for federal security purposes under the Atomic Energy Act and possession by retired law enforcement officers who are not otherwise a prohibited possessor under law. In 1989, prior to the enactment of the 1994 legislation, the George H.W. Bush administration had banned the importation of foreign-made, semi-automatic rifles deemed not to have a legitimate sporting use. It did not affect similar but domestically manufactured rifles. The Gun Control Act of 1968 gives discretion to the Attorney General of the United States to choose whether to authorize a firearm or ammunition to be imported or brought into the United States under what is known as the Sporting Purposes Test. Following the enactment of the federal assault weapons ban, the ATF determined that certain semi-automatic assault rifles could no longer be imported even though they were permitted to be imported under the 1989 Sporting Purposes Test because they had been modified to remove all of their military features other than the ability to accept a detachable magazine, and so in April 1998 prohibited the importation of 56 such rifles, determining that they did not meet the Sporting Purposes Test. Criteria of an assault weapon. Under the assault weapons ban of 1994, the definition of semi-automatic assault weapon included specific semi-automatic firearm models by name, and other semi-automatic firearms that possessed 2 or more from a set certain features. Semi-automatic rifles able to accept detachable magazines and 2 or more of the following: folding or telescoping stock, pistol grip, bayonet mount, flash suppressor, or threaded barrel designed to accommodate one, grenade launcher. Semi-automatic pistols with detachable magazines and 2 or more of the following: magazine that attaches outside the pistol grip, threaded barrel to attach barrel extender, flash suppressor, hand grip, or suppressor. Barrel shroud safety feature that prevents burns to the operator. Unloaded weight of 50 ounces, 1.4 kilograms, or more. A semi-automatic version of a fully automatic firearm. Semi-automatic shotguns with 2 or more of the following: folding or telescoping stock, pistol grip, detachable magazine. The ban defined the following semi-automatic firearms, as well as any copies or duplicates of them in any caliber, as assault weapons. Name of firearm pre-ban federal legal status: Norinco, Mitchell, and Poly Technologies Avtomat Kalashnikovs, AX, all models, imports banned in 1989 *. Action Arms Israeli Military Industries Uzi and Galil imports banned in 1989 *. Beretta AR-70, SC-70, imports banned in 1989 *. Colt AR-15 legal. Fabrique National FN/FAL, FN LAR, FNC imports banned in 1989 *. SWD, MAC type, M10, M11, M11/9, M12 legal. Starog imports banned in 1989 *. INTRA Tech 9, Tech DC9, Tech 22 legal. Revolving cylinder shotguns such as, or similar to, the Street Sweeper and Striker 12 legal. Cosmetic features: Gun control advocates and gun rights advocates have referred to at least some of the features outlined in the federal assault weapon ban of 1994 as cosmetic. The NRA Institute for Legislative Action and the Violence Policy Center both used the term in publications they released in September 2004 when the ban expired. In May 2012, the Law Center to Prevent Gun Violence said, the inclusion in the list of features that were purely cosmetic in nature created a loophole that allowed manufacturers to successfully circumvent the law by making minor modifications to the weapons they already produced. The term was repeated in several stories after the 2012 Aurora shooting and Sandy Hook Elementary School shooting. Senator Marco Rubio cited this issue during a town hall forum, responding to questions from survivors of the 2018 Stoneman Douglas High School shooting in Parkland, Florida. Legal challenges. A February 2013 Congressional Research Service, CRS, report to Congress said that the assault weapons ban of 1994 was unsuccessfully challenged as violating several constitutional provisions. The report said that challenges to 3 constitutional provisions were easily dismissed. 7. The ban did not make up an impermissible bill of attainder. 31. It was not unconstitutionally vague. And it was ruled not incompatible with the 9th Amendment by the Ninth Circuit Court of Appeals. Challenges to 2 other provisions took more time to decide. 7. In evaluating challenges to the ban under the Commerce Clause, the court first evaluated Congress's authority to regulate under the clause, and second analyzed the ban's prohibitions on manufacture, transfer, and possession. The court held that it is not even arguable that the manufacture and transfer of semi-automatic assault weapons for a national market cannot be regulated as activity substantially affecting interstate commerce. 8912 It also held that the purpose of the ban on possession has an evident commercial nexus. 9:14 The law was also challenged under the Equal Protection Clause. It was argued that it banned some semi-automatic weapons that were functional equivalents of exempted semi-automatic weapons and that to do so based upon a mix of other characteristics served no legitimate governmental interest. The reviewing court held that it was entirely rational for Congress to choose to ban those weapons commonly used for criminal purposes and to exempt those weapons commonly used for recreational purposes. 10 It also found that each characteristic served to make the weapon potentially more dangerous, and were not commonly used on weapons designed solely for hunting. 1011 The federal assault weapons ban was never directly challenged under the Second Amendment. Since its expiration in 2004, there has been debate on how it would fare in light of cases decided in following years, especially District of Columbia v. Heller, 2008. Studies on effectiveness of the legislation. A 2002 study by Coper and Roth found that around the time when the ban became law, assault weapon prices increased significantly, but this increase was reversed in the several months afterward due to a surge in assault weapons production that occurred just before the ban took effect. In 2003, the Task Force on Community Preventive Services, an independent, non-federal task force, examined an assortment of firearms laws, including the AWB, and found insufficient evidence to determine the effectiveness of any of the firearms laws reviewed for preventing violence. A 2004 critical review of firearms research by a National Research Council committee said that an academic study of the assault weapon ban did not reveal any clear impacts on gun violence outcomes. The committee noted that the study's authors said the guns were used criminally with relative rarity before the ban and that its maximum potential effect on gun violence outcomes would be very small. In 2004, a research report commissioned by the National Institute of Justice found that should the ban be renewed, its effects on gun violence would likely be small, and perhaps too small for reliable measurement, because rifles in general, including rifles referred to as assault rifles or assault weapons, are rarely used in gun crimes. That study by Christopher S. Coper, Daniel J. Woods, and Jeffrey A. Roth of the Jerry Lee Center of Criminology, University of Pennsylvania found no statistically significant evidence that either the assault weapons ban or the ban on magazines holding more than 10 rounds had reduced gun murders. The authors also report that there has been no discernible reduction in the lethality and injuriousness of gun violence, based on indicators like the percentage of gun crimes resulting in death or the share of gunfire incidents resulting in injury. In 2004, the Brady Center to Prevent Gun Violence examined the impact of the assault weapons ban on target, the impact of the 1994 Federal Assault Weapon Act. Examining 1.4 million guns involved in crime, in the 5-year period before enactment of the Federal Assault Weapons Act, 1990-1994, assault weapons named in the Act constituted 4.82% of the crime gun traces ATF conducted nationwide. Since the law's enactment, however, these assault weapons have made up only 1.61% of the guns ATF has traced to crime. Page 10 of the Brady Report, however, adds that an evaluation of copycat weapons is necessary. Including copycat weapons, the report concluded that in the post-ban period, the same group of guns has constituted 3.1% of ATF traces, a decline of 45%. A spokesman for the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, stated that he can in no way vouch for the validity of the report. A study conducted by Dube in 2013 showed that the passing of the FAWB in 1994 had an insignificant impact on violent crime in Mexico, while the expiration of the FAWB in 2004 combined with political instability was correlated with an increase in gun-related homicides among Mexican municipalities near the border. Also in 2013, Koper reviewed the literature on the ban's effects and concluded that its effects on crimes committed with assault weapons were mixed due to its various loopholes. He also concluded that the ban did not seem to affect gun crime rates, but may have been able to reduce shootings if it had been renewed in 2004. Research by gun advocate John Lott found no impact of these bans on violent crime rates, but provided evidence that the bans may have reduced the number of gun shows by over 20%. Koper, Woods, and Roth studies focus on gun murders, while Lott's look at murder, rape, robbery, and aggravated assaults. Unlike their work, Lott's research accounted for state assault weapon bans and 12 other different types of gun control laws. In a 2013 report, Samantha Bricknell from the Australian Institute of Criminology, Frederick Lemieux, and Tim Prenzler compared mass shootings between America and Australia and found the 1996 NFA coincided within the cessation of mass shooting events in Australia, and that there were reductions in America that were evident during the 1994-2004 U.S. federal assault weapon ban. Efforts to renew the ban. The assault weapons ban expired on September 13, 2004. Legislation to renew or replace the ban was proposed numerous times unsuccessfully. Between May 2003 and June 2008, U.S. Senator Dianne Feinstein, DCA, and Representatives Michael Castle, ARDA, Alcee Hastings, DFL, and Mark Kirk, RIL, introduced bills to reauthorize the ban. During the same time, Senator Frank Lautenberg, D. New Jersey, and Representative Carolyn McCarthy, D. New York, introduced similar bills to create a new ban with a revised definition for assault weapons. None of the bills left committee. After the November 2008 election, the website of President-elect Barack Obama listed a detailed agenda for the forthcoming administration. The stated positions included making the expired federal assault weapons ban permanent. 3 months later, newly sworn-in Attorney General Eric Holder reiterated the Obama administration's desire to reinstate the ban. The mention came in response to a question during a joint press conference with DEA Acting Administrator Michelle Leonhardt, discussing efforts to crack down on Mexican drug cartels. Attorney General Holder said, "There are just a few gun-related changes that we would like to make, and among them would be to reinstitute the ban on the sale of assault weapons." Efforts to pass a new federal assault weapons ban were made in December 2012 after the Sandy Hook Elementary School shooting in Newtown, Connecticut. On January 24, 2013, Senator Feinstein introduced S-150, the Assault Weapons Ban of 2013, AWB 2013. The bill was similar to the 1994 ban, but differed in that it would not expire after 10 years, and it used a one-feature test for a firearm to qualify as an assault weapon rather than the two-feature test of the defunct ban. The GOP congressional delegation from Texas, and the NRA, condemned Feinstein's bill. On March 14, 2013, the Senate Judiciary Committee approved a version of the bill along party lines. On April 17, 2013, AWB 2013 failed on a Senate vote of 40 to 60.
Please subscribe and thanks for watching.